Our next speaker is going to be Paul Hart, and I know this is, he's been dealing with the Public Utilities Commission over this whole issue of what the legalities are. And, you know, the more that any of us study this, the more we realize that the Cal-Am proposal is fraught with some huge legal problems, and a lot of it's the wells. It's a lot of it's a whole series of things, and you know, these aquifers are, you know, interrelated, where the water comes from, et cetera. But I'm going to let him speak and give his clarification about how he perceives this from a legal point of view. He's from Salinas, and we're very happy to have him here.
Great, thank you very much, and thanks for having me this evening. At the outset, I think it's important for everyone here to understand that I'm familiar with this project in two separate roles. And what I want to do is to try and present you with as unbiased of an opinion as I can as to what the significant legal issues are here. The two roles that I have served is, one, I worked on behalf of Nataraga and the People's Project in negotiating with the City of Pacific Grove the terms of the proposed formation agreement. And so I am very familiar with each of the terms of this agreement, the manner in which those negotiations went back and forth, and the concerns that were raised by the city manager that frankly I would like to address some of those here this evening. The second capacity is my representation of WaterPLus before the PUC with regard to challenging some of the actions by Cal-Am. In particular, Cal-Am's opinion that it is not subject to the Monterey County Ordinance, which requires that a public entity own and operate a desalination facility within Monterey County. So I don't know what is going to be the most important issue to each of you, and so I will leave open for questions those legal components that you're most concerned about. But I would like to address some of the issues raised by the city manager of Pacific Grove and concerns about entering the formation agreement with Nataraga and the People's Project for desal. I met with members of the City Council and with the city manager in April and May of this year to negotiate the terms of an agreement, the formation agreement, that would allow the start of a project for the desalination plant in Moss Landing. It's important to understand what the scope of this initial agreement is. It's an agreement that the parties will jointly work together to evaluate the realistic probability of success of that project. For that, Mr. Aga promised to put forward $600,000 to cover the city expenses, plus a 10% margin for the expenses of the city employees and the time, and to cover all of the third-party costs associated with this initial stage of evaluation. If that amount of money was insufficient to cover all of the expenses of the city of Pacific Grove, the city only need ask. All they have to do is submit a written statement to Mr. Aga that says, we need more money, otherwise we're going to withdraw from the project. It's that simple. This $600,000 is not a cap. It is the initial commitment of Mr. Aga. That is what today he's promising to give. It doesn't say that there won't be more in this initial stage. It sets forth a procedure for the city to ask for that additional funding. The goal of this initial investment is for both parties to determine whether this ultimately can be a successful plan, a successful project. If in fact they get to the point where both are confident that it will be a successful project, then they would sign a subsequent agreement to try and develop the desalination project. The goal, as we are in this initial stage, this initial $600,000 and the initial environmental review, is for the city of Pacific Grove, frankly, to serve as a leader, to say, we believe in this county that it is important that the public own the water and not a private company. And we all know that there has not been any success among any other governmental entity to stand up and say, we're going to do this, we're going to move it forward. I believe, as Ron indicated, that if Pacific Grove does this and says, this is going to work, we're going to move the ball forward, that there will be other public agencies that will join on. And I think that that's an important component, because in order for there to be true public ownership of the water, it's not one municipality. It is the members of this county. And I think that the people in this room, look, there are a million different reasons that someone can say, I think that this is going to happen or that's going to happen in the future, and 10 steps down the road, this may not work. But the question is, what public entity is going to stand up and say, I think we can make it work. I think we can have public ownership of our water in this community. And once one of them does it, I believe that ultimately others will join, because it's the right thing. Now the question is, during that initial period of time, is Pacific Grove subjecting itself to risk? And the simple answer is no. And I want to respond to some of the insinuations to the contrary. First of all, the $600,000 is an initial sum. Additional monies will be deposited upon request. The city of Pacific Grove has the absolute right to withdraw from this at any time, at any time. If additional funds are requested and not received, Pacific Grove can walk away. And it is structured in such a way that Pacific Grove's bills to that point in time will never exceed the amount on deposit. Second, there is an indemnification clause. The indemnification clause says that if the city of Pacific Grove is found liable to any third party or sued by any third party for any bodily injury, economic harm, or for any breach of this agreement by Mr. Aga or his company, that he will fully pay, not just for potential liability, but for the cost of defending that. This is the language that was proposed by the city of Pacific Grove. I will tell you that I recommended against Mr. Aga signing this. It was an issue at the initial city council meeting, because I said this language is too broad. It subjects him to too much exposure. It's not what you would see in a typical commercial contract, where indemnification would be more restricted. And initially he said, you know, I don't feel that comfortable with it. The city came back and at the council's request said, you know, this is what we need to protect the city of Pacific Grove. Mr. Aga immediately withdrew his opposition and accepted the language that was proposed. It doesn't get any better than the indemnification language that you have here. And if anybody is taking a risk due to the scope of this indemnification provision, it's Mr. Aga, not the city of Pacific Grove. I think that there are other important issues. You have heard, or there's a suggestion of some potential liability for environmental contamination at the site to the city. I will tell you that is simply a red herring. That is something that is absolutely, first of all, not founded in fact, as you've heard. There is no groundwater contamination nor any ground contamination at that site. Second of all, if there is any concern whatsoever, the only potential types of exposure that you can have for being a purchaser of a property that may be contaminated are under federal legislation, under CERCLA and RCRA. I've handled both types of cases, okay? There is an absolute procedure. It's set forth in the Revitalization Handbook, published by the EPA, okay? the EPA says that its most important mechanism for covering and protecting and revitalizing environmentally harmed areas is local government purchasing and acquiring and revitalizing the property. All any government purchaser has to do is follow the steps laid out here, and they get a letter from the EPA saying you are going to be immune from liability. There are 4 separate mechanisms that they can go through to do that, and all of that can be done before they ever purchase the property. So it's simply inaccurate to say that there could be any exposure whatsoever, either from a long-term lease or a purchase of the property. That should be dealt with in advance, undoubtedly, but it could be the site inspection can occur, the EPA can completely sign off on the project and completely insulate the city of Pacific Grove. The litigation risks. There are several references to concern by the city of Pacific Grove or the city manager that someone might sue the city of Pacific Grove for something and cause them to incur legal fees. I don't know how to respond to that. It costs $435 to sue someone. Okay? Anyone in this room could be sued by anyone, and all it takes is a check for $435. What I can tell you is that Mr. Aga has promised $150,000 up front that can be used to cover legal fees for the city of Pacific Grove, any expense associated with joining this formation agreement, and has every intention of pledging more if it's moving in the right direction. Okay? I don't know what kind of risk the city manager sees, and so I can't really respond to it. As far as I can tell, there is nothing that CalAm could have any legitimate legal claim to say that somehow the city of Pacific Grove is liable for launching an alternative desalination project. Competition in this country is not unlawful. There is nothing about what the city of Pacific Grove is doing to take over the project that was previously being promoted by CalAm. In fact, this is going down a completely separate track. This is not going to go before the PUC and be regulated by that entity. This is going to go through the standard court, local environmental review, and be evaluated by the citizens and the courts of this community. Okay? It's interesting contrast to the position that CalAm has taken. CalAm's position is only the PUC has any control over us. When they didn't like the answer that they got from our local courts, their answer was, we're not going to fix what you said was wrong with our environmental analysis. What we're going to do is go to the PUC and say that they have exclusive jurisdiction over us, that they are the lead environmental agency, and that the members of this community and the courts of this community don't have any say in what water project is advanced. And I think that that's the wrong answer. And I think that the members of this community believe that that's the wrong answer. And so it comes back to the question of why should Pacific Grove participate? Pacific Grove is a small community. It typically would not be looked to lead this type of large-scale project that likely will benefit the entire Monterey Peninsula. The answer is that we need a public leader. We need a public leader. Ultimately, for this to be successful, there will have to be other followers. I think everyone agrees with that. The question is, who's going to step up and say, we need a competitor to CalAm? The truth is, the worst thing that happens by promoting an alternative proposal is that you now have legitimate competition. You don't have CalAm saying, I can simply charge you $1.3 trillion. The worst thing that happens is you have a legitimate competition where they have to drop their prices They have to try and answer to the members of this community rather than simply to the PUC. And you have a viable alternative that is solely financed by one private individual from your community. The public gets the benefit of that competition. And that's what happens under a worst-case scenario. The best-case scenario is that the project succeeds and you now have public ownership of water, not private ownership of water for a profit.